Thus, the supreme law of the land positively and explicitly excluded religion from any consideration whatever on the part of the national government. And then, 1 year prior to the wound, 1 year prior to he that led into captivity go into captivity, the year 1797, the Treaty of Tripoli was made. And it was signed by President Washington, approved by the state of the United States, in which it is declared that the government of the United States is not in any sense founded upon the Christian religion. This was the beast rising out of the earth with its gentle, innocent, lamb-like horns. If you come to the year 1887, there was enacted by the Senate and the House of Representatives an act stating that it shall be unlawful for any person, company, partnership or corporation in any manner whatsoever to prepay the transportation or in any way assist or encourage the importation or migration of any alien or aliens, any foreigner or foreigners into the United States, its territories or special, expressed or implied, made previous to the importation or migration of such alien or aliens, foreigner or foreigners, to perform labour or service of any kind in the United States, its territories, or the District of Columbia. There was an issue in America where the large corporations were paying for cheap labour to come into America. And the cheap labour would arrive there and they would be put in the positions of the Americans. Not only were the Americans losing their jobs, but those that had jobs were in competition with these immigrants because they were happy to work for lower wages. Thus, the wages of America started to decline. So the government in 1887 enacted a law forbidding any importation or migration of an alien or aliens to perform labour or service of any kind in the United States, its territories, or the District of Columbia. In 1892, there was a situation where the Trinity Corporation in New York City hired a preacher to come from England. Accordingly, the corporation was brought before the Supreme Court. Well, at first, the Circuit Court decided that the church was guilty and rendered judgment accordingly. An appeal was taken to the Supreme Court of the United States upon writ of error. The Supreme Court reversed the decision, first upon a well-established principle that the intent of the lawmaker is the law. The court quoted directly from the reports of the Senate committee and the House committee who had the bill in charge when it was put through Congress. And these both said in express terms that the term labourer or labour service used in the statute was intended to mean only manual labour or service. The Act itself had actually said to perform labour or service of any kind. But they interpreted that law as just speaking of a labour or labourer service was intended to mean only manual labour or service and not professional service of any kind. Therefore, that being the intent and the only intent of the law and the intent of the lawmaker being the law, the Supreme Court reversed the decision of the lower court and said that the act complained of was not a violation of the law. Simple, seemingly irrelevant court case. Nothing to do, seemingly, with an image to the beast. So far as that decision went, it was acceptable. And it needed to go no further. But between the paragraph of that decision that stated what I've just read and the closing paragraph of the decision, there was brought in and made an essential part of the decision, a mass of matter not only totally irrelevant to the case, but wholly beyond the rightful jurisdiction or the proper cognizance of the court. After a break, we will have an examination into what else was in that and its consequences.